The Committee on Oversight and Government Reform to come to order. The committee meets today to consider a resolution to determine whether Lois Lerner waived her Fifth Amendment privilege against self-incrimination when she made a voluntary opening statement during the committee's hearing that began on May 22, 2013. The clerk will designate the resolution.
A resolution of the Committee on Oversight and Government Reform.
Without objection, the resolution will be considered as read and open for amendment at any point. The text has already been distributed and is in your folders. I now recognize myself for an opening statement. We are here today to resolve an important issue the committee and the United States House of Representatives has. Did Lois Lerner waive her Fifth Amendment privilege against self-incrimination during the committee hearing that began May 22, 2013? During the hearing that began on May 22, more than 5 weeks ago, I tried to be exceedingly cautious. I did not make a quick or uninformed decision on the waiver. Because a decision is one that does not often get made, and it is extremely important both to the discovery of Congress in its duties, and quite candidly, toward the real question of whether or not people will come and give one side of a story and not allow themselves to be cross-examined. As Chairman, it is my obligation to be fair and impartial and to lead this committee not on one side or the other, but to the greatest extent possible to make my decisions in concert with the parliamentarian, with House counsel, and consistent with what we would want to have if and when the gavel moves to the other side of the aisle. My job as Chairman is to bring the question to a vote so the committee could make a determination. As most know, when Congressman Gowdy made his assertion during the hearing, I could have ruled just that she had waived. I felt it inappropriate to do it, recessed the committee hearing, and informed Ms. Lerner that she was subject to recall after a decision was made. We have consulted and gotten advice with House counsel. Their capacity as attorneys for the committee and for the Congress is impartial. They have delivered to us both their opinion and the case law. Having now considered the facts and arguments, I believe Lois Lerner waived her Fifth Amendment privileges. She did so when she chose to make a voluntary opening statement. Ms. Lerner's opening statement referenced the Treasury IG report and the Department of Justice investigation, and the assertions she previously had provided and the assertions that she had previously provided false information to the committee. She made 4 specific denials. Those denials are at the core of the committee's investigation in this matter. She stated that she had not done anything wrong, not broken any laws, not violated any IRS rules or regulations, and not provided false information to this or any other congressional committee regarding areas about which committee members would have liked to ask her questions. Indeed, committee members are still interested in hearing from her. Her statement covers almost the entire range of questions we wanted to ask when the hearing began on May 22nd. Today marks the 37th day since Ms. Lerner appeared. Since that time, I have considered the matter deliberately. I have received letters from Lerner's lawyers that presented her arguments clearly and completely. Her letter will now be entered in the record without objection, so ordered. We considered it and sought appropriate counsel to reach our decision. Counsel had her attorney's letters and made their determination and recommendation. And now it's time to put it to a vote. With that, I recognize the ranking member for his opening statement.
Thank you very much, Mr. Chairman. To date, this investigation has been characterized by a series of unsubstantiated accusations by members of Congress with no evidence to support their claims. And today's proceeding is the latest unfortunate example. I often say that I would like our committee to operate more like a courtroom by gathering evidence in a responsible and impartial way before drawing conclusions or making judgments. If this were a courtroom, the first question to Ms. Lerner would have been, how do you plead? Ms. Lerner would have been able to state her innocence, and she never would have been forced to take the stand, swear an oath, or publicly assert her Fifth Amendment rights. In this case, Ms. Lerner's attorney wrote to inform the committee before the hearing that his client would exercise her Fifth Amendment right. But unlike in a courtroom, the chairman issued a subpoena forcing her to appear, made her stand and swear an oath, and challenged her Fifth Amendment assertion by posing questions to her anyway. So now the chairman wants the committee to conclude as a legal matter that Ms. Lerner waived her rights because she made a statement professing her innocence. Now, if this happened in a courtroom, which it can, a judge likely would hold a hearing on this question before making a ruling. Counsel would prepare written briefs with legal and historical precedents, and the judge would hear oral arguments from all parties involved before making a determination based on the facts and based on the law. But again, this is not happening here. The chairman is going about this in reverse. He's asking the committee to vote on his resolution first without taking basic common sense measures to help committee members, all committee members, both Republicans and Democrats, make reasoned and informed decisions. Let's look at the evidence now before the committee. Exhibit A is a letter from Ms. Lerner's legal counsel, William Taylor, on May 20th, 2013, clearly invoking her Fifth Amendment rights. And I ask that this letter be entered into the record.
Without objection, so ordered.
Exhibit B is a detailed letter from Ms. Lerner's counsel on May 30th, citing extensive legal precedent by the Supreme Court, circuit courts, and district courts explaining that, and I quote, "And a witness compelled to appear and answer questions does not waive her Fifth Amendment privilege by giving testimony proclaiming her innocence," end of quote. The chairman never responded to this letter, to my knowledge, or legal precedents it contains. I ask that this letter be entered into the record.
It's already in the record.
Exhibit C is a statement from Stan Brand, who served as House counsel from 1976 to 1983, stating, and I quote, "I do not believe Ms. Lerner's brief introductory profession of innocence, in which she offered no substantive testimony or evidence, constitutes a waiver of her Fifth Amendment rights." I ask that that document be entered into the record.
Without objection.
Thank you, Mr. Chairman. Exhibit D is a statement from Daniel Richmond, a law professor who served as the chief appellate attorney in the United States Attorney's Office for the Southern District of New York, stating, and I quote, "As a matter of law, Ms. Lerner did not waive her privilege and would not be found to have done so by a competent Federal court," end of quote. I ask that that document be entered into the record.
Without objection, all inclusions on your list will be entered in the record.
Thank you very much, Mr. Chairman. Exhibit E is a letter I sent to the chairman on Wednesday citing additional authorities and requesting a hearing with legal experts on both sides so members could consider this issue in a reasoned, informed, and responsible way. I ask that that document be in the record, and I understand it will be. So with all this information now before the committee, what is on the other side? The chairman has a memorandum from House counsel on this issue that he has declined to let all the members of the committee see. His position evidently is that only he and I can review the memo, so that the memo is not in the record before us. In my letter to the Chairman on Wednesday, I asked that—
Would the gentleman—
Yes.
Would the gentleman please yield for—
Sure, of course.
The instruction was that it cannot be released publicly since House counsel represents us. You're certainly free to have each individual member as long as they're bound by the same understanding. Our counsel is subject to attorney-client privilege, and that's the reason that counsel's advice, and you receive separate counsel advice directly from House counsel, as I understand, that's a decision that you make relative to the normal rules of attorney-client privilege.
Well, I thank you reclaiming my time. I try to pay appropriate deference to the Chairman, and through staff memos. This is a memo, Mr. Chairman, dated June 26, 2013, 8:07 p.m.
Yeah, and I'm reading it, and I will take such time as necessary. I'd also ask that you not distribute it widely, parentheses, like to all members. The fact is, it says, next, it says, it is reasonably foreseen that a wide distribution could lead to public disclosure. The staff member that gave you this without a prohibition on any one of your members reading it. The concept would be that members could read it, they could seek independent counsel. Every member on both sides of the dais can go to House counsel and seek an independent decision on their own. We simply were recognizing we did not want public disclosure, as you and I would not want public disclosure of any attorney representing us.
I understand that, but all I'm asking you, are you saying then, because I have not divulged one syllable of this counsel's opinion to my members in accordance with what I thought you were saying. Now, if you're saying that my members can have it and
your members can seek counsel directly, and
no, that's not what I'm asking you.
Your members can read it, and Suzanne, who was the recipient of that, is well aware of that. We are dealing, you and I may be rusty, but we both have good counsel. The fact is that every single member of the House can seek House counsel, and you did seek and receive a separate note from House counsel, and this only implies not to lead to public disclosure, nothing
fine.
more.
I just want to make sure that my staff, I want now from our members, since I made a mistake, Mr. Chairman. Apparently, I was under the impression that you were saying that my members could not see what they're going to be relying on from counsel, and I'm asking that it be distributed to our members now, and it not be disclosed to the public.
I would caution members, if they want to see any further, they can, but this is attorney-client privilege. This is your attorney or your group of attorneys at House counsel, but their recommendations, their citings are available to any member.
All right. Now, so that we'll be clear, and I just want to, and again, I'm trying to stay within the bounds that I thought were set. If members want to ask, once they read it, ask about it, is that out of bounds? I'm just going to, you follow what I'm saying? In other words, my members are now going to be reading what you depended upon to hold this hearing.
This is a markup. The resolution is available for amendment. It was distributed pursuant to the rules. Ms. Norton, I know, has a stripping amendment. The fact is that we have had 37 days, plenty of public and private debate. We have sought counsel. I've chosen to use a resolution, Mr. Cummings, even though I had the right to rule, and had I been comfortable ruling without seeking additional advice from parliamentarian and also the House counsel, I would have. But this resolution is effectively a ruling of the Chair that Ms. Lois Lerner waived in her activity, and we're really voting on a ruling of the Chair, but it's in the form of resolutions so that it's available for amendment. And I would caution members, they're free to use their 5 minutes and so on. I'm not going to limit debate, but this is a markup. It is like any other markup. and I've chosen to do that so that my ruling would be published and open to a vote rather than simply the procedural tabling of the chair that otherwise would happen.
Mr. Chairman, I'm almost finished now. Thank you very much. In my letter to the Chairman on Wednesday, I asked that every member be given the opportunity to hear directly from House counsel and pose any questions they have about the legal standards and historical precedents he believes are controlling, but the Chairman declined to honor my request. So here's what may happen if we continue down this path. The Republicans could adopt the resolution on a partisan vote. The Chairman could force Ms. Lerner to return and direct her to answer questions. Her attorney, no doubt, will disagree with the legal basis for the resolution, and Ms. Lerner will continue to assert the fifth, after which the Chairman could schedule a vote to hold her in contempt and send the entire matter to a Federal court. After all that happens, however, the record before the court will be the record we established today. The committee has held no hearings on this significant constitutional issue. The committee has taken no testimony from any legal experts. The Chairman never responded to the legal precedents from Ms. Lerner's counsel. The Chairman never responded to a request by her counsel to testify before the committee and answer members' questions. The Chairman declined my request for a meeting to allow members to hear directly from counsel. The Chairman chose not to allow all committee members to review the opinion, and that's just been changed. Thank you, Mr. Chairman. And the committee adopted no report or other analysis of the applicable legal provisions and the historical precedents. Let me close by making clear that I want to hear Ms. Lerner's testimony. I think her testimony is very, very important. I agree that she has information that is relevant to the committee's investigation. For example, I want to ask, why did she not inform Congress in 2012 of the improper practices she discovered in 2011? But we must respect the constitutional rights of every witness who comes before this committee. And whatever your interpretation of the law is in this instance, we should all agree that this is not a responsible record to put forward, because it undermines the credibility of this committee and the legitimacy of the resolution itself. So my request stands. I ask that the committee first take the preliminary common-sense step of holding a hearing to obtain testimony from legal experts before requiring committee members to vote on this very significant constitutional question. Otherwise, as a member of the Congress who has sworn to uphold the Constitution, I cannot in good conscience support this resolution. And with that, I yield back.
If the gentleman would yield.
Of course.
You had a number of questions there. No, I will not hold a hearing. No, I do not agree with your position that you were denied any access to counsel. The opinion that was shared with you out of courtesy was an opinion we sought, which means that we gave you more than would ordinarily happen. You could seek.
When you say we, I just want to make sure I understand what you're saying.
The House counsel information that was shared with you, we requested and we shared what we got back with you.
Who is we? That's all I'm asking.
The majority.
Okay, that's what I thought. Okay.
The fact is that you can seek counsel. Every member can seek counsel. Having said that, I find it odd that you would decide that we need to make a record before the court. If this were to go to a Federal judge, the Federal judge would be considering only Ms. Lerner's actual activity and would be making a decision clearly de novo. Having said that, I cannot, nor would any chairman of either party, hold hearings every time there is misbehavior or improper conduct of a witness.
Yeah.
You can understand that the committee cannot be turned into everyone coming and doing that.
Mr. Chairman.
Ms. Lerner was here pursuant to a deposition, pursuant to a subpoena, and was represented by counsel.
Mr. Chairman, just one moment. Mr. Chairman, I'm not trying to make this more difficult than it should be. It's just that I think that when we are dealing with, I'm very sensitive to this Constitution, because I wouldn't be here if it wasn't for it. And when we're dealing with people's rights, I think that we need to make sure that at least, the only thing I was asking, and I know you've denied it now, and that's all well and good. The only thing I was asking is that we make sure that the members, when they vote, they have access to the legal sides of this argument. There are clearly two sides, but the chairman is the chairman, and so I yield back.
I thank the gentleman. All members, I'll hold the record open until the end of the day for any member who would like to submit a written statement. Does any member wish to speak on the bill or offer an amendment?
Mr. Chairman.
The gentleman from Florida.
Again, from the perspective of being here, a senior member of the panel, never seen an instance in which a witness would thwart our responsibility in such an offensive manner. I'm saddened that the ranking member would not work with us on moving forward. He said some things that are correct. He said some things that are dramatically wrong. First of all, if you hold up the Constitution, just open it up, and it has three distinct branches of government. In fact, a legislative branch, an executive branch, and a judicial branch. Rights are contained at the end in the Bill of Rights, and we want to comply with those. But in fact, the right of this committee and the Congress to conduct its business as set forth by the Constitution is being attempted to be thwarted by a government employee. Our job, we were sent here to review the conduct. It's clear in the Constitution our responsibility on this committee is very important to conduct oversight and investigations. We are the chief panel in the House of Representatives. Lois Lerner is a Federal employee who failed to appear at our request. Under the rules of the House and this committee, she was issued a subpoena. She appeared. She was given the opportunity to exert her Fifth Amendment. She, in fact, waived that right by giving her testimony and her position, thumbing her nose at this rightful committee under the Constitution and our legislative authority. Lois Lerner is, in fact, a poster child for thumbing her nose, a Federal bureaucrat thumbing her nose at Congress. And I'm telling you, I've absolutely had it with what we've seen, the power of this new estate. It's not in the Constitution that there is a fourth branch that can tell us to go to hell. We have a responsibility to investigate what was going on. She's given her rights, and what the ranking member said at the end is correct. We will follow the process. The decision here today is this committee to act on the resolution, and in fact, this individual has thwarted the responsibility of this committee to investigate for her to testify. Now, she'll be given the opportunity when she comes back to take the Fifth, but in fact, we are voting today on the fact that she waived it. That's a committee decision. We have the right to make that. We should back our chairman and the committee for the precedents for the future. This may not always be on, a Republican majority, and it's important that this precedent for the future be set. Today's a showdown, really, in who's in control of the government and whether we honor the Constitution, the rules of this committee, and our responsibility as members of Congress sent here on behalf of people who are out there this morning, got up in the middle of the night, working, paying their taxes, expecting us to oversee what the bureaucrats are doing. And in fact, when you have the financial arm, the IRS of the United States, spinning out of control, as we've seen in this instance with a bureaucrat, again, thumbing her nose at us in our process, there's something dramatically wrong. So I urge the adoption of this resolution. She'll have her day to come back. She'll have her right to exercise her Fifth Amendment right, and the ranking member is correct. She may be held in contempt in the future. But again, this is in fact, a showdown today between an emerging bureaucracy that has spun out of control. And if you don't see it, folks, you're in trouble and the system's in trouble. I yield back.
Thank you. For what purpose does the gentlelady from District of Columbia seek recognition?
At the appropriate time, Mr. Chairman, I have an amendment in the nature of a substitute.
The clerk will designate the amendment.
Amendment in the nature of a substitute to the resolution of the Committee on Oversight and Government Reform offered by Ms. Norton of the District of Columbia.
The amendment will be considered as read and distributed to all members. The gentlelady is recognized.
Thank you, Mr. Chairman. This committee is fond of citing the Constitution. I offer this resolution in order to allow us to show we mean it. I agree with the Chairman that a hearing here would be unusual, and then when there is purported misconduct, we don't have a hearing on it every time someone objects. But I think it is also clear that this is a novel issue and a close question. And all one has to do is to look at the authorities and see how they line up on both sides of when a witness waives her constitutional rights. Both sides are anxious to question Lois Lerner because she may be the witness in the only position to get to the root of where the origin of the controversy involving the IRS was. Justice Department has itself opened an investigation. Ms. Lerner took the Fifth Amendment and issued a short statement proclaiming her innocence. I have looked at the authorities, and the reason I offer this amendment in the nature of a substitute is that although I have spent most of my professional life when I was not a public official, either as a practicing lawyer or as a law professor, a tenured professor of law as I am still today, I have no immediate opinion, pro or con, and still do not. I only had a few minutes on my own to scant the authorities. So I decided to write this resolution last night only upon learning that there would be a vote on this matter, and I would have to vote that an American citizen had waived a constitutional right. That is a very heavy burden. I learned that there had been correspondence from the ranking member, that there had been an expert opinion from House counsel. That counsel was regarded as an attorney-client matter, was not available to us. I learned further, of course, that Ms. Lerner's counsel had written to the committee to offer his authorities that she did not waive her constitutional right. Clearly, wherever you come down on this issue, there are decidedly different precedents on when an American citizen waives her constitutional right, including her Fifth Amendment rights. I do not see any basis for the committee to conclude that the question of waiver is clear and settled on the information before us now. My resolution might well yield no different result from what the chairman seeks through his resolution. But it calls for a hearing that, at the very least, would educate members sufficiently to make them feel comfortable in actually voting that an American citizen had waived a precious constitutional right. The Fifth Amendment has become perhaps the most unpopular amendment of all the amendments in the Bill of Rights, but it was one of the favorites of the framers. no court would strictly construe a waiver of any constitutional right without more information than we have before us now. We are not a court, but I had thought the committee took seriously, even revered, the Constitution. The Fifth Amendment has a long and storied history in this Congress, much of it among the most discredited in the history of this body. The point of calling Lois Lerner was to discover what no other witness can tell us. It is still our purpose.
Would the gentlelady please wrap up?
It is still our purpose. I had hoped that we could find a way to get to the real point of hearing from her, perhaps by offering her her immunity through some kind of negotiations with her counsel, since that is what we all want. Voting to waive her constitutional rights must be the very last resort. With all respect, Mr. Chairman, I do not believe we're at that point yet.
Would the gentlelady yield?
Although we may well get to that point.
I'm going to be not supporting your amendment, but what I wanted to make clear was all the things you said, including trying to get her to give testimony, the possibility of limited immunity and so on, all of that by definition comes after Mr. Gowdy's assertion during the earlier hearing that she had waived. Ultimately, as I said earlier, and I think you were here for it, we're dealing with a motion that originated from Mr. Gowdy that she had waived, a decision that I reserved for 37 days.
Mr. Chairman, I don't understand. Are you saying that since she waived, we don't need to discuss whether perhaps she would testify if given immunity?
No, her counsel, the decision of whether she waived and the decision of whether or not they would proffer and all those other decisions, quite frankly, are not going to happen until after we conclude her testimony, which she began, continued, and then stopped earlier. She is still a witness pending from a recessed hearing. And that's really what we're doing today, is preparing to go forward with the hearing.
Mr. Chairman, have you considered offering her immunity? May I ask, have you considered offering her immunity so that we may discover the very evidence we seek from her?
Madam, I apologize, but there are some things that cannot be said in an open hearing.
And yet we are supposed to vote right now to waive her constitutional, that she has waived her constitutional rights. That is a very serious burden to put on us without more information, Mr. Chairman.
I appreciate, but Madam, we were all here or eligible to be here. We have noticed this markup pursuant to the committee rules. The gentlelady had 37 days in which to seek counsel.
37 days you noticed this hearing?
37 days in which to seek counsel as to a question of a statement made
When did you notice this hearing, Mr. Chairman?
The gentlelady's time has expired. I will now recognize the gentleman from South Carolina.
Thank you, Mr. Chairman. At first blush, the prospect of having another hearing almost seems irresistible, except for the fact that that additional hearing would not disclose one single solitary relevant fact. All facts necessary or that would be at the disposal of this committee are already in the record. Ms. Lerner is not coming back. And Mr. Chairman, I don't need law professors to come for a second hearing and read me the case law. There's not going to be one additional fact uncovered at a second hearing. So what facts do we have at our disposal? Mr. Chairman, I have identified 9 separate, specific assertions made by Lois Lerner on May the 22nd. And that was after she asserted her right against privilege. 9 separate factual assertions, including, Mr. Chairman, I have done nothing wrong. I have broken no laws. I have provided no false information to Congress. I have violated no IRS rules. I have violated no IRS regulations. And then, Mr. Chairman, she authenticated a document. All of this, Mr. Chairman, after she invoked her right to remain silent. 9 separate factual assertions and the authenticating of a document after, with the advice of counsel, I hasten to add, with the advice of counsel sitting right behind her, she testified to 9 separate factual assertions and then authenticated a document. So, Mr. Chairman, the case law to me is clear. That is not the way the Fifth Amendment works. You don't get to tell your side of the story and then avoid the very process that we have in this system for eliciting the truth, which is cross-examination. Why do we have a confrontation clause? To my colleagues on the other side of the aisle, why do we have a confrontation clause? Because cross-examination is the best technique, the best tactic for eliciting the truth. And every witness has to sit on the stand, and they have to weigh and balance. What are the benefits of saying nothing, which is my right? Or what are the benefits of getting my side of the story out? That's what you have to balance. Saying nothing versus telling your side of the story. But, Mr. Chairman, there is no contemplation in the Constitution that you tell your side of the story and you're never cross-examined. And the Supreme Court agrees with us. Mr. Chairman, these are just 2 quotes from the Supreme Court. A witness may not testify voluntarily about a subject and then invoke the privilege against self-incrimination when questioned about the details. Similarly, in Brown v. United States, a witness waives the privilege by voluntarily giving exculpatory testimony. A denial of activities that might provide a basis for prosecution constitutes a waiver of that privilege. Yes, she has a Fifth Amendment right to remain silent. She sat there and could have said nothing. We had a witness this week who did that. We had a witness this week who said nothing. She didn't. She made 9 separate factual assertions, and then she authenticated a document. If that is not waiver, if that is not express waiver, then surely it's implied waiver, and if it's not implied waiver, what is? If giving your side of it, 9 separate facts, and Mr. Chairman, I have to add this. Because aside from certain factual assertions, this witness volunteered, and this is important, she testified that she has done, quote, nothing wrong. I know my friends on the other side of the aisle will conclude that is an amazingly broad statement. It's tantamount to a double negative. I've done nothing wrong. So let's flip it around. What she's really saying is, I have done everything right. To say I've done nothing wrong is to really say I have done everything right. So, Mr. Chairman, what possibly could be a broader assertion of fact than to say I have done everything right? I want to say this in conclusion because my time is almost up. I have had private conversations with colleagues on the other side of the aisle whose opinion I respect very much. And I'm not going to disclose those private conversations other than to say I benefit from their counsel. There's some very, very good attorneys on the other side of the aisle, as there are on this side of the aisle. The way I view this, Mr. Chairman, is this is Congress asserting its constitutional obligation to provide oversight. Yes, she has a constitutional right to remain silent, and she could have invoked it, but she did not. And we have a constitutional obligation to provide oversight. So we can have another hearing. I have great respect for the gentlelady from the District of Columbia, but let's be honest with each other. There's not going to be one more fact that's part of this record. Not one. We're going to bring a law professor to say that she waived. You're going to bring a law professor to say that she did not, and we'll be right back where we are today. All of the facts that we're going to have are here right now. 9 separate factual assertions. If that is invoking your right to remain silent, then there's no such thing as waiver. No such thing.
Gentleman yields back. For what purpose does the gentleman from Virginia rise?
I wish to speak to the resolution.
The gentleman is recognized for 5 minutes.
I thank the Chair.
Mr. Chairman, I have a matter of clarification. Would the gentleman be speaking to the amendment to the resolution or to the resolution at this point?
The gentleman is recognized to speak to the amendment in the nature of a substitute offered by the gentlelady from the District of Columbia in regular order.
Could I ask that my time be restored, Mr. Chairman?
Nah, he took it.
Thank you, Mr. Chairman. I wish to support the amendment offered by the gentlelady from the District of Columbia, because I think actually there are more facts to be heard and there are other points of view to be heard. What we're about today is not to prosecute Lois Lerner, ably though our colleague from South Carolina seems to be doing. It is to ensure the protection of the constitutional rights of a citizen. Mr. Micah, my friend from Florida, referred to her as a federal bureaucrat thumbing her nose at Congress, and that's what this is about. That is not what this is about. This is first and foremost Lois Lerner, an American citizen, invoking one of the most sacred privileges enshrined in the Bill of Rights, her Fifth Amendment right to protect herself. The record will show from the very beginning, when she was summoned to this committee, she resisted, and she invoked her Fifth Amendment right. She came here under subpoena, a partisan-issued subpoena, I might add, not supported by our side, against her will. And she made a statement and then refused to answer any questions and was dismissed by the chairman, properly so. Mr. Gowdy would have you believe that the law says the fact that she made any statement at all constitutes a waiver of her constitutional right not to self-incriminate. I beg to differ. Case law is very clear that the fact that she made a statement does not somehow constitute a waiver. In fact, there's a famous case during a different era when red baiting was going on called United States versus Hogue, in which Mr. Hogue made a statement. I have never engaged in espionage nor sabotage. I am not so engaged. I will not so engage in the future. I am not a spy or a saboteur, and then invoked his Fifth Amendment. And the court found that did not constitute a waiver, just like this case, Ms. Lois. The dispositive case in law is the famous Quinn case, in which the Supreme Court was crystal clear that it is a very high standard you have to meet before you can determine that someone in fact has waived their Fifth Amendment. I think the record is quite clear. Ms. Lois intended absolutely from the beginning to invoke her Fifth Amendment and protect herself as an American citizen is entitled to do, even though we would like to hear her testimony. I would too. If we do this today, every American citizen is at risk who's ever summoned before this committee. And it could be construed, though I'm sure that's not the intent, that by insisting she appear here under subpoena and having her at that witness table, she could claim, one observer could say, it constituted an entrapment. I'm sure that's not what our intent was. But I will point out that the D.C. Bar Ethics Code says explicitly that when someone has invoked the Fifth Amendment, it is wrong to haul them before a committee, and the verb they use is, the only purpose to be served by doing that is to pillory them. That's the verb, which invokes images of different eras in American history that the Fifth Amendment was designed to prevent from recurring, like the Salem witch trials, where people were pilloried and worse. I believe that if we pass this resolution, we are trampling on the rights of an American citizen, and that trumps everything. That trumps the need for her testimony. That trumps her status as a federal employee. That trumps her status as an official at the IRS. If we're not about protecting the rights of American citizens, what are we about as members of Congress? I urge my colleagues to put aside politics here. I urge my colleagues, especially on the other side, to think carefully about what we're about to do. You may make a small political gain by passing this resolution at enormous long-term costs, and you will erode the confidence of the American people in what we're about. And there is an institutional commitment all of us need to be concerned about. And I plead with my colleagues to think carefully. Why not take some time and have a hearing so that we can air this out? I yield back.
I thank the gentleman. We now recognize the gentleman from Tennessee, Mr. Duncan.
Thank you, Mr. Chairman, and I rise to speak in opposition to the amendment in the nature of a substitute.
The gentleman is recognized.
I think the actions of the Chairman in bringing forth this resolution are entirely appropriate, and I understand that they're being done under the after the advice and under the advice of House Counsel. And I wish to second the remarks by my colleague, Mr. Gowdy. Some of you know I spent many years as a lawyer and a judge before coming to Congress, and spent the last 7.5 years as a judge trying felony criminal cases. Every article I've ever read, every case I've ever read about the Fifth Amendment would not have allowed, and in fact, as a lawyer, I never would have advised a client that they could give a statement under oath and then plead the Fifth. As a judge, I never would have allowed a defendant in my court to testify and make a statement and emphatically declare their innocence and then plead the Fifth at that point. That would make a mockery out of the Fifth Amendment. And I think it's accurate to say, I think the record will show that that I was a judge who leaned very much in favor of defendants. I was never a prosecutor, as Mr. Gowdy was, and I did everything possible as a judge to bend over backwards to make sure that all the defendants appearing in my court got every right that they were entitled to. But Lois Lerner came in here, and as Mr. Gowdy said, on 9 separate occasions emphatically declared her innocence or strongly asserted that she had done nothing wrong repeatedly. We cannot allow witnesses to testify under oath and then plead the Fifth to keep from being questioned or cross-examined. This would not be fair. It's not consistent with the history of our country and our judicial system. I think a key element here is that this committee is operating under rules somewhat different from other committees. Most other committees in the Congress do not swear witnesses and place them under oath before they testify. But Lois Lerner came in here under oath and essentially told her side of the case and then pled the Fifth, denying myself, Mr. Gowdy, and other members any opportunity to question her or to cross-examine her. And so I rise in opposition or speak in opposition to the amendment in the nature of a substitute. And I believe the actions of the Chairman in bringing forth this underlying resolution are entirely appropriate and consistent with all the legal precedents and history in this country. Thank you very much.
Would the gentleman yield?
Yes.
I thank the gentleman. I take a short moment to respond to my good friend from Virginia who spoke so eloquently about the sanctity of the Fifth Amendment. I think it is important, and it's important that somebody be represented by counsel. Of course, Ms. Lerner was. And I think it's more important to realize that, most important to realize that she made voluntary decisions, not just the decision to make an opening statement that made claims and assertions on point, but then to answer additional questions after she had invoked her Fifth Amendment privilege, to answer additional questions. I'm not an attorney, even though I serve on judiciary and obviously have this obligation here today. That's why we sought counsel and we took the time. It is the result of recognizing that there is both a legal precedent for this, and I know many people here have not seen legal precedent, have not taken the time for it over the last 37 days. But I think the important thing is the respect for the Constitution is also respect for the fact that if somebody comes and gives testimony, they become subject to cross-examination. And the decision here today is, did she give testimony and then choose to take the Fifth, and is she subject to that cross-examination? Now, I know everybody here in this room, if they were accused of a crime or even just being sued, they would want a right to cross-examination, rights to the allegations made by people. She made allegations, And we, the people, would like to simply cross-examine what she said, having been informed and, in my opinion, waiving her right. I thank the gentleman for yielding and yield back. For what purposes does the gentleman seek recognition?
Address the amendment.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, look, I think this is an incredibly serious question put to this committee. I think all of us, both sides of the aisle, want to hear what Ms. Lerner has to say and what information she may bring. We all want to do our job and get on with the investigation that underlies all of this. But I think we all, hopefully, are just as concerned about making sure that this committee upholds the Constitution, particular Fifth Amendment rights of any citizen on that, no matter what we think of the citizens' earlier activities or statements. I'm concerned that this is sort of an unusual proceeding, that she was subpoenaed. Her attorney made it very clear that she was going to plead the Fifth, and yet we continue to force her to come in before the committee. And as Mr. Connolly said, you know, what for? To pillory her, to make an example of her, to put her in a situation where she might then be forced to waive. I mean, in the judicial process, and I think Mr. Connolly made it clear, that's not the usual way of proceeding. In fact, in this D.C. bar, it would be considered a questionable ethical practice to put somebody in that kind of an untenable situation on that. So I'm concerned from the outset of what that was all about, whether it was about spectacle or it was really about trying to move this matter forward on that. I'm also concerned that we're really dealing with an issue of law here, not so much fact, as my colleague indicates on that. You're asking this group of mostly non-lawyers, or if they're lawyers, not necessarily constitutional lawyers, to make a decision based on some complicated legal questions, and it's not as cut and dried as some might wish it were. There's opinion on both sides, and we've had some days in the interim when we realized that the chairman was going to move in this direction to seek out some advice, and we got advice that was conflicting on both sides. I think responsible and credible lawyers and constitutional experts who opine on either side of the issue. And I think it deserves a full exposition here, as this amendment would do, of having experts come in or brief us and testify as to what underlies their opinions on that. I know that the former House counsel stated that Mrs. Lerner's brief introductory statement to the committee, not given in response to any specific question, was simply a profession of her innocence, offered prior to the commencement of member questioning regarding the substance of the committee's inquiry. It contained no factual representations relating to the subject matter of the hearing and generally denied wrongdoing, and he would not have recommended that she be brought in for contempt or found that she had waived her rights. Another legal expert from the Columbia Law School, Professor Daniel Richman, makes very clear in his opinion that Ms. Lerner's willingness in response to the chairman's request that she authenticate her prior statements to TIGTA, deprive her of the Fifth Amendment privilege, did not happen. The court noted if a witness makes an admission in an affidavit submitted in a proceeding, she may lose her ability to invoke the privilege when asked about the substance of that admission later in the proceeding. But willingness to authenticate, to simply admit that the prior statements were made without any concessions of their veracity, is not testimony of the substance of prior statements, and he gives citing for that. So there is conflicting information back and forth on that, and although the chairman now indicates that members were supposedly allowed to see his requests for House counsel opinion, I'm looking at the email went back and forth, which says, I'd also ask that you not distribute it widely, parentheses, like to all of your members, close parentheses. So my question would be, which one of the members over here, Mr. Cummings' minority, would you like not to see this? Would you not like to be fully briefed and informed before they made this decision? Which one of the members over here apparently have different status than the members on your side, who you apparently were willing to share this with in advance? And I think that's entirely unreasonable and unfair and should not have happened, and that kind of a statement is offensive, I think, to people who might be included in that category on that basis. So we've not had ample time to have an exposition of all the facts. We have been deprived, because how was Mr. Cummings to determine which, like to all of your members, were applied on that? I see some eyes rolling over there, but the fact of the matter is—
Would the gentleman yield?
I will in a second. I want to make this point as clearly as I can, that I'm reading. It says, the ramifications are bad for the House. I'd also ask that you not distribute it widely, like to all of your members. I will yield only if the gentleman wants to tell us which one of all of these members that the majority did not want to see that report.
Gentleman yield?
I'll yield for that purpose.
I want to say the chairman should not have to answer that question.
I'm sorry that you're offended that we offered any sharing of an opinion. No,
Gentlemen,
of
I'm
opinion.
going to reclaim my time. If you're not going to answer what I yielded you to
I
answer.
am trying to answer your
Well,
question. The fact is, you're saying you were offended. This was an opinion given to the majority on my request. This was the chairman's
He's
request.
the House
And
counsel. He gives an opinion to the members of the House.
no, that is not correct.
So which members over here did you not want to see that report?
The gentleman's time has expired.
Well, the gentleman's excuse is lame, too.
We now go to the gentleman from Pennsylvania, Mr. Meehan.
Thank you, Mr. Chairman. Mr. Chairman, as I sit through this, I think we're losing a little bit of focus about what the purpose of our inquiry is here in the first place. And while I have great respect for the gentleman from Virginia and, frankly, great regard for the gentlelady from Washington from the district who has looked at this from the perspective of both sides of the equation, we're doing a great deal to talk about the characterization of Lois Lerner and the idea that somehow we're here attempting to embarrass the witness. I go back to the point, we are not here with regard to Lois Lerner. We are here because there were American citizens who were affected by the agency that she oversaw, who used their authority in the IRS to what we believe to be an oppressive fashion against what could be their constitutional rights and potentially in a criminal fashion. And so what we really have here is we're engaged here in a civil proceeding. And the extent to which Lois Lerner has rights that she can invoke using her Fifth Amendment, they relate to any ultimate question that she may be accountable for in a criminal forum, not here. Now, what she says here may be relevant, and certainly there's plenty of history with regard to that issue. But let's go through the facts of what happened here. We are here in a civil proceeding, and we do have a responsibility, an oversight responsibility to address precisely that which we just articulated, which is the responsibility to assure that the rights of citizens have not been oppressed by the IRS. Lois Lerner does not have any right to refuse to answer questions before this committee unless they would, in fact, incriminate her. She may, in fact, even, and it's not uncommon in the civil practice of law, for a person to come in and to be deposed, and in a normal course of questionings go through, she has competent counsel, and there will be a series of questions, and they will be answered. And at some point in time, counsel will take a particular question and say, that goes to the potential, that it might be a meaningful basis that it could incriminate her criminally. And there's a broad reading of that. And I suspect if Lois Lerner comes back here before, she's going to invoke the Fifth Amendment with respect to quite a few bits, in fact, not everything. But the fact of the matter is what changed the dynamic here was with competent counsel sitting at that table, some of the best attorneys available, and Lois Lerner is an attorney herself who practiced in the Department of Justice. And so she comes here with a higher degree of awareness of what she was doing. She voluntarily changed the dynamic. When she chose to use this forum, a forum in which she was quite aware that there was going to be national forum for her to declare whatever it is that she wanted to do. And she used this occasion very specifically. And the gentleman from South Carolina went through and articulated very eloquently the number of ways in which she opened the door. I have in my hands here the letter from counsel. We knew what she was doing by invoking the Fifth. All she had to do was sit there and say, I invoke the Fifth. End of case. We wouldn't be here today. But she's the one that put into this record the subject matter. She opened the door to the subject matter. She is the one that included the references to the IG report, which talked about inappropriate activity on the part of the IRS and talking about specifically potential political activity that was inappropriate. She is the one that brought the IG's report into this. She is the one who talked about the issues that were before her prior testimony before committees, and then made these statements. I did not break any laws. I did not violate any IRS rules or regulations. I did not give any false testimony to this or any other congressional committee with respect to all of the things that had just previously been identified. That is the subject matter in which she put it into play. That is a voluntary waiver, and a determination on her part with counsel sitting right behind her. We are here today because Lois Lerner made a choice. She made a choice to use this forum for her purposes. And I asked this committee to remember why we were here, not for Lois Lerner, but to make sure that we stand up for the rights of those who have been oppressed by the IRS. I conclude my comments by saying Lois Lerner is not surrendering any Fifth Amendment rights because we can foresee what's going to happen down the line. To the extent that she will invoke Fifth Amendment privilege and we would hold her in contempt, it will go before ultimately a qualified court of law. And there it will be briefed, and there they will have the best of attorneys if in fact it gets to that matter. And prior to that, there may be decisions for other kinds of activities this committee would make that would make that issue not relevant. But as to today, as to this moment, Lois Lerner opened the door, and she can't have it both ways. And I believe at this point in time, this is a simple resolution, which is simply saying that we have the ability to ask her to come back to answer questions with regard to the issues that she opened the door to. And she may ultimately then invoke her Fifth Amendment, and we will be back at a further proceeding. But this is not something that violates her rights, and I urge my colleagues to support this resolution. Thank you.
The question is on agreeing to the amendment offered by the gentlelady from the District of
Mr.
Columbia,
Chairman,
Ms. Norton. All those in favor will signify by saying aye. All those opposed? No. In the opinion of the Chair, the noes have it. The noes have it. The amendment is not agreed to.
Mr. Chairman, I asked to be
Are you asking for a roll call vote?
No, I asked to be recognized for 5 minutes.
I did not recognize the gentleman.
Yeah, I know. You talked right over me, sir.
Are you requesting a roll call vote?
No, I'm asking for 5 minutes to speak.
You'll have 5 minutes on the amendment. Okay. On the resolution.
Mr. Chairman, I'm asking for a roll call vote.
You're very welcome. The clerk will call the roll.
Mr. Issa?
No.
Mr. Issa votes no.
What's that?
Mr. Micah?
Yeah.
Mr. Micah votes no. Mr. Turner? Mr. Turner votes no. Mr. Duncan? Mr. Duncan votes no. Mr. McHenry? Mr. Jordan? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Walberg? Mr. Walberg votes no. Mr. Langford? Mr. Amash? Mr. Amash votes no. Dr. Gosar? Dr. Gosar votes no. Mr. Meehan? Mr. Meehan votes no. Dr. Desjardins? Dr. Desjardins votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Farenthold? Mr. Hastings? Mrs. Lummis? Mrs. Lummis votes no. Mr. Woodall? Mr. Woodall votes no. Mr. Massey? Mr. Massey votes no. Mr. Collins? Mr. Collins votes no. Mr. Meadows? Mr. Meadows votes no. Mr. Bentivolio? Mr. Bentivolio votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Cummings? Yes. Mr. Cummings votes aye. Mrs. Maloney? Mrs. Norton?
Yes.
Ms. Norton votes aye. Mr. Tierney?
Aye.
Mr. Tierney votes aye. Mr. Clay? Aye. Mr. Clay votes aye. Mr. Lynch?
Aye.
Mr. Lynch votes aye. Mr. Cooper?
Aye.
Mr. Cooper votes aye. Mr. Connolly?
Aye.
Mr. Connolly votes aye. Ms. Spear? Ms. Spear votes aye. Mr. Cartwright?
Aye.
Mr. Cartwright votes aye. Mr. Pocan? Mr. Pocan votes aye. Mrs. Duckworth? Mrs. Duckworth votes aye. Ms. Kelly? Ms. Kelly votes aye. Mr. Davis? Mr. Davis votes aye. Mr. Welch? Mr. Welch votes aye. Mr. Cardenas? Mr. Cardenas votes aye. Mr. Horsford? Mr. Horsford votes aye. Ms. Luan Grisham? Mr. Jordan, you are not recorded.
Mr.
Jordan?
Hastings, how do you vote?
No.
Mr. Hastings votes no.
Does anyone else seek recognition for the vote? The clerk will report.
On that vote, Mr. Chairman, 20 noes, 16 ayes.
The amendment is not agreed to. Since we have a vote on the floor and wanting to leave ample time on the underlying resolution, we will stand in recess after. We'll do one more on the underlying. Yeah, we'll stand in recess until 5 minutes after the last vote.